Welcome everyone to the 10th meeting of the Senate Judiciary Committee. I would ask all members and guests to please silence your phones. Mr. Secretary, please call the roll.
Senator Carroll.
Here.
Senator Deneen.
Here.
Senator Neal. Senator Nemes.
Aye. Here.
Senator Reed.
Here.
Senator Stivers. Senator Thomas.
Here.
Vice Chair Wheeler.
Here.
Chair Storm.
Here. It appears we have a quorum present and are duly constituted to do business. Members, does anyone have a guest they'd like to introduce? Senator Thomas.
Thank you, Mr. President. Mr. President, I see here my good friend, Mr. Chuck Eddy, who is the lead manager for the Moms to Man Action Group in Central Kentucky. I would ask Chuck to stand. And Chuck, thank you for being here today.
Seeing no other members with a guest, we'll go ahead and turn to Senate Bill 195. It's first on our agenda, an act relating to civil causes of action sponsored by Senator Craig Richardson.
Good morning, Mr. Chairman and members of the committee. I'm Senator Craig Richardson, representing District 3.
Please have your guests identify themselves as well, please.
Good morning. My name is Stephen Henderson. I'm an attorney with Stites and Harbison and serve as legal counsel for the Kentucky Association of Highway Contractors.
You may proceed.
Thank you, Mr. Chairman. I think we have a committee sub to
Motion on the
first.
sub.
We have a motion, second. All in favor say aye. Aye. Any opposed? Ayes have it. The sub is adopted.
Thank you, Mr. Chairman. That's important because the sub essentially whittles this down to exactly what we're presenting today and focusing specifically on civil liability with highway contractors. At its core, this bill is about fairness, aligning responsibility with those in decision-making authority in roadway construction and maintenance cases. Today, contractors who complete projects according to government-approved plans can still face prolonged litigation, even after that work has been inspected and accepted. Senate Bill 195 brings needed clarity to that situation. It establishes that when a contractor follows the plans and fulfills the contract, there is a presumption that they have done their job correctly. Importantly, that presumption can still be challenged. If a contractor deviates from the plans or creates a dangerous defect, they remain fully accountable. The bill also addresses situations involving extreme driver behavior, such as impairment or driving far above a speed limit. In those cases, it allows that conduct to be considered a substantial factor in causing harm while still preserving the ability for all evidence to be evidence to be weighed. Additionally, Senate Bill 195 clarifies a common sense principle that design responsibility should rest with the party that made design decisions. Contractors are responsible for how they perform their work, but not for engineering judgments made by others, unless they took on that judgment themselves. Finally, the bill makes clear that contractors should not be held liable for conditions outside the scope of their work, unless they voluntarily assume that responsibility. This legislation does not eliminate claims, does not cap damages, and does not protect negligent actors. What it does is provide a structure and predictability in how liability is evaluated in our court system, ensuring that responsibility is placed where it truly belongs. Senate Bill 195 supports a fair legal framework, promotes efficiency in public infrastructure projects, and protects both taxpayers and responsible businesses. Thank you, Mr. Chairman.
We have a motion on the bill by Senator Carroll. We have any questions? Seeing no questions, we have a second. We have a second by President Stivers. Mr. Secretary, please call the roll.
Senator Carroll.
Aye.
Senator Deneen.
Aye.
Senator Neal. Senator Nemes.
Aye.
Senator Reed.
Aye.
Senator Stivers. Senator Thomas.
Mr. Chair, I'd like to explain my aye vote.
Yes, please.
Let me begin by saying that I am not one who believes in immunity actions. Generally, I do not support those when they come to this legislature. I didn't even support those during 2020, during COVID. because I'm a lawyer, and I remember when I decided to go to law school over 50 years ago, I believe that everyone should have access to justice. I believe that then. I still believe that the courthouse door ought to be available to everyone to pursue whatever claims, rights, or actions that they believe to be important. And the court should always be open to at least hear those actions and provide justice to everyone. So I'm not in favor of immunity actions. However, Senator Richardson, you know that you and I sit next to each other every day on the Senate floor. And I have a lot of respect for you, and I think you're a good senator. And so I'm going to allow this bill to get to the Senate floor and be voted upon. I'm not going to promise you that I will vote for this when my name is called on the Senate floor. But out of respect for you, I will allow this to go to the Senate floor and let it have a full hearing. And so for their reason, I vote today, Mr. Chair.
Thank you.
Thank you. We're going to go ahead and go back to President Stivers. Oh, I'm sorry. Okay.
Senator Wheeler,
Mr. Chair, explain my aye vote.
Yes, please.
I want to commend the sponsor for drafting a product that does not close the courthouse doors to people who may be injured in an accident. I think I would probably consider one of the strongest defenders of the Seventh Amendment down here. But I think it's important to establish a reasonable framework, and I believe this bill is amended as it pertains to highway contractors does that. It does preserve a cause of action for those who are injured by negligent actions. I think that's the most important thing. I guess what I would say often that, sometimes the tight deadlines within the statutes of limitations sometimes cause you to bring people in that you might not otherwise want to bring in because you're not given adequate time to fully investigate claims, or something actually comes up in litigation that you weren't aware before. And if you don't have an opportunity to amend that complaint and bring them in because of a timeline at that time, sometimes the way the system is structured, forces you to do that. So that's I think, something that needs to be made aware of. But in its amended form, I think this shows that folks on both sides can be reasonable. I appreciate you taking the concerns of KJA into account, and for that reason, I am supportive of the bill.
Chair Storm,
I'm going to vote aye today in committee. I'd like to explain that. As Co-Chair Wheeler pointed out, I think this is a lot better piece of legislation. I appreciate you working on it and narrowing down the focus. I do have an anomaly in my hometown. I've shared that with you regarding a construction project that was recently completed. But again, I think this is a good piece of legislation that's narrowly focused, and I appreciate your work on this and your advocacy for your position and listening to the concerns that Senator Wheeler and the members of this committee had as you move this piece of legislation forward. So for today's purposes, I will vote aye. Does anyone like to explain their vote? President Stivers.
Thank you, Mr. Chair. I want this to be known. I don't know if we really got into this, but if the road contractor operates within the specs as given to them by the sovereign, which is us, and they stay within that, then you shouldn't hold that contractor for acting at the direction of the sovereign. Now, if they go outside that scope, game's on.
Correct.
So their game's on at that point. But within the scope of the sovereign, and there is still, even if within the scope of the sovereign, the ability to go to the boards of claims against the sovereign, which is capped at, I think, $200,000 now. So I don't want people to think that this thing precludes someone from making a claim if the sovereign or the contractor is at fault. But the contractor shouldn't be held liable for something that the state or the sovereign has put before it and operated within those parameters. And that's why I think this is a good piece of legislation.
Thank you, Mr. President.
Thank you for your explanation. With 8 yes votes, 0 no votes, and 0 pass votes, Senate Bill 195 as amended by the committee substitute is passed and will be reported with favorable expression. Same should pass. Thank you, Senator. Next on our agenda is Senate Bill 290. I think I have some guests here in the room. If you could make your way to the table very quickly. And this is a bill regarding criminal history, sponsored by myself. And as those individuals are making their way to the table, we recently passed a Senate bill called Senate Bill 110. It was in the Transportation Cabinet or Committee, and that was a modernization of the AVIS system, hopefully to get to the CAVIS system and have electronic filings and things of that nature. And what this bill does is it basically takes the paper version of the expungement process and it converts it into the electronic system, because AOC is currently working on an electronic database that will be up and running in 2032. And members, please take note that this bill does not go into effect until 2032, but what we're trying to do is establish the framework for the legislation so that the AOC can build the apparatus. At this time, please identify yourselves, and you have the floor.
My name is Brittany Bogart. I'm from Hopkinsville, Kentucky.
I'm Kate Shanks. I'm Senior Vice President of Public Affairs for the Kentucky Chamber.
Adam Haley, Senior Director of External Affairs for Goodwill, Kentucky. Joey Comley, I'm the Kentucky State Director for Right on Crime.
Please pull your microphone a little closer, and then you have the floor, ma'am.
Chair and Senate committee members, thank you for the opportunity to speak today in support of Senate Bill 290, the Clean Slate Kentucky Act. I also want to thank Chairman Storm for sponsoring this bill and all the legislators who have shown their support. Your leadership makes second chances possible. My name is Brittany Bogart, and I'm from Hopkinsville, Kentucky. I'm also a person with lived experience in the justice system. And today I serve as a city council member, the first formally justice-involved elected official in our state. My path here was not easy. I experienced severe trauma as a child, abuse, and homelessness and instability. I became involved in the justice system at a young age and carried that involvement into my adulthood, accumulating dozens of charges. For years, my life was defined by my record, but I changed. I put in the work to rebuild my life. And when I was finally able to access expungement, it changed everything. Not just on paper, but in reality. It allowed me to work, to go back to school, to provide for my children, and to serve my community. Since then, I've helped more than 400 people in Western Kentucky clear their records. And I can tell you the biggest barrier isn't willingness to change, it's the system. It's complicated, it's expensive, and out of reach for too many people who have already done everything right. That's why Senate Bill 290 matters. The Clean Slate Act would automate expungement for eligible Kentuckians. It would ensure that people who have earned a second chance actually receive it, without needing a lawyer, without navigating a complex process, and without falling through the cracks. This is not about erasing accountability. It's about recognizing transformation. It's about removing barriers that no longer serve public safety, but instead hold people back from working, supporting their families, and contributing to their communities. Kentucky is full of people who have done the work to turn their lives around. Senate Bill 290 gives them a real chance, not just hope, but opportunity, by allowing people to fully participate in the workforce and support their families. This bill strengthens not only individuals, but entire communities across our state. Last week, I had the opportunity to speak about Senate Bill 290 here at the Capitol, and Lex 18 featured my story in an article. Since then, this issue has gained tremendous attention. I've received hundreds of calls across the state from people who need expungements. Emails, messages, not from only Kentucky, but Alabama, Tennessee, and even had people call me from New York. National news outlets have expressed interest in covering the story. Kentucky now has the chance to be a national model for giving people a hand up and not a hand out, and helping them rejoin society and contribute meaningfully. I am standing here today because someone gave me that chance. This bill makes sure that chance isn't an exception, it becomes the standard. I respectfully ask for your support of Senate Bill 290. Thank you.
We do have some people that signed up to speak against this. You all want to go ahead and get your testimony in very quickly?
Sure. Thank you, Chairman. Thank you for the opportunity to speak in support of this legislation. I thought I'd go back to 2016 when the bill regarding felony expungement passed. It was House Bill 40. The Kentucky Chamber was at the table in support of this bill. And I want to say that the Chamber had robust conversations about this policy when we took the position in support. And we looked at it through the lens of workforce and how we can help working families, working Kentuckians remove barriers to work. You know, you see us up here all the time talking about taxes, infrastructure, economic incentives, but we have to also talk about not just creating jobs, but making sure we have the people to fill the jobs. Our work on expungement is part of our work to support workers and working families. Our leaders decided this policy was important for supporting Kentuckians who, despite making mistakes, want to get their lives back on track. We are not just an organization that supports legislation and then you adjourn, sine die, and we go home and we stop thinking about it. We have a foundation that offers programming. We have trained around 426 employers on policy and best practices to support hiring people with criminal backgrounds or people that struggle with substance use disorder. We also work with our friends at Goodwill and Fifth Third Bank to do expungement clinics. And then we also come before you at times to say, you know, this is legislation we've passed in the past or that you have passed, and that it's time to tweak that or reform the legislation to make it better. And that's what Senate Bill 290 does. And that's why we're here in support of it. It recognizes that despite the path that exists, many still struggle to get an expungement. We can make changes, we can do more, and that's what Senate Bill 290 does. We will continue to offer the programming that we offer, to work with our partners on expungement clinics, but we think this legislation is an important part of the equation to help people get back on track and get back in the workforce. If we're going to continue to grow our economy, we got to create jobs, and we track jobs in Kentucky, but we have to make sure we have the people to fill those jobs as well so that we can get the economic growth that we know we can see. Thank you.
Thank you, Mr. Chairman, for introducing this important legislation. You know, Goodwill comes at this, like the Chamber, from a workforce perspective. We see it because it's a workforce issue because employment rates for individuals with criminal record are much lower. And we find that with expungement, we see a 10% increase in their earning, or 10% increase in their workforce participation, and an earnings increase on average of about $6,000. We looked at the data and saw that about 1.1 million adults in Kentucky have some kind of record, and if even only 10% of those were to get their eligible for clean slate and to have their record expunged, that's nearly $220 million in increased wages and the associated tax revenue to go along with it. So up to this point, Goodwill Kentucky has expunged over 20,000 records for 6,400 people, just like Brittany, one of our graduates, since our program started in 2021. In partnership with the legal aid societies across the state and folks like Kentucky Chamber, Fifth Third Bank, and a number of partners who support this work along with us. But under this existing process, it takes about a year to prepare the petitions, get a court date, and appear in front of a judge in order to get the expungement ordered. And it usually takes several more months after that for police and local officials to expunge those records. That is after the mandatory 5-year waiting period that the existing statute has in place. Expungement creates opportunities for people to earn credentials and secure better jobs while getting back engaged in civic life in their communities. You know, one story we hear time and time again is, I can't take my kids on a field trip because I have this record. So we work with folks to get back engaged with school, with civic life. And, you know, we've heard, and we likely will hear, some concerns about public safety and concerns about that. But, you know, a 2019 study from the University of Michigan showed that people who obtain expungement reoffend at rates comparable to the general population anyway. And considering that the population that we're serving already would statistically see higher rates of offending to start with, that's a marked decrease. This is arguably due in part to some of the waiting periods that exist in statute, as the likelihood of reoffending decreases with age. With that, I'm happy to turn it over to Joey.
Thank you. We have several bills on the agenda. We have some individuals signed up to speak. I'll give Joey a rebuttal here in a moment if he chooses. So thals individuals that signed up to speak against this bill, I think it's Judge Ward and Lewis Kelly. I didn't know you were going to be here today, Judge Ward. It's good seeing you. I didn't receive any communication from you, nor you, Mr. Kelly. So please identify yourselves for the record, and you have the floor.
Thank you. I'm sorry I didn't give you notice. I didn't know it was on the agenda till last night about 8 o'clock, so I decided to come on down. But I'm Judge Julie Ward. I'm a circuit judge in Campbell County. I've been on the bench about 22 years. And I'll let Lewis Kelly introduce himself.
My name is Lewis Kelly. I'm the Commonwealth's attorney for Kentucky's 54th Judicial Circuit, comprised of Boone and Gallatin counties, and I am the immediate past president of the Kentucky Commonwealth Attorneys Association.
So I'm sure Lewis Kelly will talk a little bit about danger to the public. One of the things that I would just want to hit upon is that if a defendant does get an expungement, and if in fact he does have contact or she has contact with the criminal justice system again, we judges don't know that. We won't ever get to see it. So it would be nice if there would be some sort of way that judges would be able to see if somebody does reoffend, what their criminal history is, because it simply is unfair to sentence someone as a blank slate and police officers to encounter someone as a blank slate when they have not reformed their life. They're continuing to have contact with the criminal justice system. So I'll start with that. But what I really want to end with is that this bill, what it does is it radically changes things for judges because it takes us out of the equation for a large part. Currently, judges have discretion. I mean, we have the right to decide if we still think someone's a danger to the community, and we can deny an expungement because of that danger.
And that's based upon a motion filed by the Commonwealth Attorney or the county. How does that work, Judge? Because it can be objected to, correct?
It can, but the court can still object also.
Sure.
Meaning, so a petition gets filed. I don't think the process is complicated. I've seen a lot of petitions. I've expunged a lot of records. But it's a petition. You just go down to the clerk's office and ask for a simple petition. It's very simplistic form. And then all they have to do is ask for a record. And normally the clerks will even tell them you have to get your KSP record. I've only had maybe one or two in my career that have not had a KSP record. And when they come to the court system, I just say, hey, I'll hold this in abeyance, for about 30 days. Go get your KSP record and come back and let me know you're ready. And a lot of other judges do that too. And then they just order their KSP record, and then you get it and take a look and see if they're eligible. And you'll listen if there's any objection, but you'll also take into consideration anything they want to give you. I just had a hearing a couple months ago. A defendant wanted to bring in some testimony, and I had my hearing, listened to the testimony. It's not a very complex process, honestly. It does give accountability to defendants to basically say, if you want to have your record expunged, you do have to go in front of a court. You do have to let the judge who signed the order of conviction, who signed the order of judgment, the right to decide whether, in fact, she or he wants to put their signature on an expungement. What this bill does is basically tells a judge, if the clerk decides that someone's eligible for expungement, then what I have to do as a judge, if there is no objection, I have to be a secretary, meaning I just review the clerk's work to see if they adequately and appropriately complied with the statute in terms of whether they met their 5-year mark or didn't meet their 5-year mark. And then I have to put my signature on it. So I would assume that you all would probably not like to sign your names to something that you would not agree to.
And if the county attorney or Commonwealth attorney, your colleague sitting next to you, if they object to it.
I won't even see it.
If they object to it.
I won't see it.
If they object to it, there's still a hearing, correct?
No, there's not under the statute. What it is that if they object, it goes immediately to the clerk of courts, and the court should not expunge it. So what it does is it bypasses me entirely. It gives me no discretion whatsoever. It's making me sign my name without having the ability to decide whether I think it's appropriate for the community. The danger to the community is completely wiped away. There is no reviewer of danger to the community other than the executive branch of government. But the executive branch of government is not signing their name. It's me signing my name. If you all want, respectfully, if you want legislative expungement, because that's really what this is, then I shouldn't have to sign my name at all. Just bypass me. Just
Thank
complete.
you, Judge.
And I just want to make one other point, but I'll shut up.
No, go ahead.
The only other thing I want to say is that there is an onus on the courts. So, like, if I expunge something, I will put in my order, these are the agencies that should do the expungement. You really don't have to do that because there are agencies by statute that will just get the expungement. But in this particular circumstances, it says the court shall basically ensure that the expungement is happening. I don't have any mechanism to call the KSP and everybody else and say, did you expunge that? How's that working? Did you make sure you did your job? It's not my responsibility to do that. I can do an order telling people to do something, but I shouldn't have to follow up with it. So that was all I wanted to say.
I'll try to
No, go ahead, Mr. Lewis. Go ahead.
I'll
Or
try to be
Mr.
very
Kelly, whatever.
brief. Our opposition to this bill, and we've been opposed to it for a long time, at least bills similar to this, is but one, logistically and from a policy side. On just the logistics, right now, because there is a filter in the sense that you have to apply for expungement, it limits the amount of review we have to do of cases. I would say we probably review between 3 and 5 per week in the 54th Judicial Circuit, perhaps more. The number would increasingly go up, and so there is a logistic issue to that, and I think that's a concern of the circuit clerks in which I've talked to them.
Actually, the circuit clerks are neutral, sir. I've
Well-
spoken with them.
Well, then I'll say individual circuit clerks I've spoken to, maybe not as an association, but individual circuit clerks I've spoken to have expressed concerns about the logistics of handling the volume. if
When
it's
this
not
goes
just-
into effect in 2032?
Yes, sir.
Okay.
And then the other part is, I don't think you'll find any objection from my association in terms of making the process simpler. I know in my district, they don't even have to appear in court. If they have filed the paperwork and we've reviewed it and they are eligible, we won't oppose and the judge will grant the motion. I'm not opposed to reducing fees, but I do think there's a utility that having someone actually go there and fill it out goes to whether or not they're actually serious about changing their lives. And I think there's utility if they're not willing to go and file a petition for expungement of knowing their criminal history. I do know that if they don't and they're still a convicted felon, that can place protections. If they're not willing to do that and they own a firearm, they're still a convicted felon and they can't own firearms. There's just a lot of utility. We just don't think it's too much to ask, and it's just a policy position that we have that we think people should still have to apply, but we do not have objections to making that process simpler and not unduly burdensome. Thank you.
Thank you for your testimony. Did Joey have any follow-ups really quickly or not? Is he still here? Oh, Senator Thomas, go ahead.
Yes, I have a question for Judge Ward, if I may.
Very quickly. We have several bills on the agenda. Thank you. I wasn't aware she was coming today. Thank you, Judge, for your time. That's fine.
Give me at least 3 minutes.
Go ahead.
Judge Ward, as you've heard me say already, I'm an attorney. I live in Fayette County, and I've been before judges around Central Kentucky, and I have a lot of respect for the judiciary. We have excellent judges in this state. We have this adage in this country that says that if you have been found guilty of a crime and you serve your time, then you've paid your debt to society, and now you're clean and everything can start over. Listen to your testimony today. Do you agree with that adage, or do you disagree with it?
So, Senator, I definitely agree in second chances. But what this expungement bill does, it's not second chances. It's second, third, fourth, fifth, sixth, 7, 8, 9, 10. And there does become a point where it's not about a second chance. It becomes about a pattern of behavior. Meaning, if you have someone who has a pattern of behavior, we should try to determine if that pattern of behavior is going to exist as it continues in the future. And what this bill does is it doesn't allow judges to see if there's a pattern of behavior. It doesn't allow the community to see if there's a pattern of behavior. What it is basically, I have to take the word for somebody. I've changed. I won't do this again. And I know how many times I've heard that in my career? A lot, sir. A lot.
Any further questions?
Thank you so much, and thank you for your kind words.
Very quickly, if you have any rebuttal.
30 seconds, Chair and honorable members. I just want to point out to the group that, what exists before you today in Senate Bill 290 is a product of 2 years of collaborative efforts in a work group chaired by Senator Storm and Rep. Nemes. It involved community partners. It involved AOC, KSP, judges, prosecutors, defense attorneys, and all the concerns that those folks had should have been brought to the forefront and addressed in the bill that sits before you today. Thank you.
Thank you. Seeing no further questions, I'd entertain a motion on the bill. I'll make a motion. Do we have a second? Senator Thomas seconds. Mr. Secretary, please call the roll.
Senator Carroll. Senator Deneen.
Explain my vote.
Yes, please.
When I first got the bill and looked over the bill, I had my reservations, but I've recently heard from some folks back home, county attorneys, and so that still have some concerns with the bill. So I don't want to slow the bill's process, but at this time I'm going to be a pass, and then I am going to reserve the right to change that on the floor if it moves forward.
Senator Neal. Senator Nemes.
Explain my aye vote, please.
Yes, please.
I'm for you pay your time, you pay your dues, that you have a second chance. I am a little leery of a judge signing off on something they may not agree with. We're getting on judges now for letting people out at their decision and signing off. So that is one concern of mine, but I am an aye vote.
Senator Reed. Aye. Senator Stivers. Aye. Senator Thomas. Aye. Senator Wheeler.
Explain my vote, Mr. Chair.
Yes, please.
Generally, I've had some concern because I do believe that it's part of the process of taking responsibility to go down and I've heard people testify that it's so awful that they have to go hire a lawyer. I don't know why nobody thinks they should have to pay a lawyer in life, but that does seem like a regular refrain that we hear. But I do believe that some of the judges' concerns are valid, specifically the one enumerated by Senator Nemes, maybe if there's something we could do to that effect. But I guess I would note that, it does say that they shall have had no contact with the justice system, that the person, I think under the Section 1, subsection C3, the person has not been convicted of a felony or misdemeanor in the preceding 5 years, and that there's no proceeding or for a felony or misdemeanor pending or instituted. So that does give me some comfort that we're not necessarily looking at repeat offenders with the justice system. But I can understand the judge's concern about not wanting her signature on a document over which she has no control. That might be a conversation worth having. But for the purposes of moving along in the process, since we're kind of late in the game, I am an aye vote on the. Thank you, Chair.
Chair Storm.
I vote yes.
Senator Carroll.
Mr. Chairman, I'd like to explain my no vote.
Yes, please.
And I want to mention that those that are victims, I want you to know that there are people that think about you, and I always have struggled with these bills because it seems that all the conversations in Frankfurt these days are about making offenders whole, and I don't hear a whole lot about victims anymore. And from a law enforcement career, I know of cases where you've had an individual that, and I know this has been very much limited on the offenses, and I appreciate that, but you look at a burglary third degree, and I can remember cases where you would have an individual over a 6-month or a year period that could have committed 20, 25 third degree burglaries. And if I understand this correctly, 5 years after all this is done, that would automatically come off that person's record. I struggle with that. If you have crimes that occur in successive years, eventually all of those are going to come off that record. I agree with 1, 2, maybe 3 chances, and I think people are given those chances through the court system time and time again. But the process is in place where the judges do have the discretion, and I struggle with the automatic aspect of this and the fact that there could be multiple offenses, not just one mistake, but multiple, with multiple victims that or could be out financial hardships because of burglaries. They never get their materials back. So therefore, Mr. Chairman, I am a no vote.
Just as it relates to, you finished, Senator, I'm sorry. Yeah, I just wanted to clarify that we did work with Zero V and KSAP on this, and specifically excluded from this bill were violation of protective orders, violation of interpersonal protective orders, stalking, second degree, strangulation, second degree. Additionally, there were other language added to make sure that prosecutors had 90 days to object. There was also another list of excluded items that you mentioned: forgeries, criminal possession of forged instruments, commercial fraud, fraudulent business acts. So we tried to make sure that the victims were consulted, and I think they could be even here in the room, and they did have a part in this bill. Thank you.
Mr. Chairman, I do appreciate those efforts, and you have worked very hard to make this as sound as it can be. And I'm not saying I won't be an aye when it comes down to it. I'm still struggling at this point.
I understand. Thank you for your vote. So with 6 yes votes, 1 no vote, 1 pass vote, Senate Bill 290 is passed and will be reported favorably with the expression same should pass. Thank you. Now turning to House Bill 4, an act relating to grooming of a minor, sponsored by Representative Mary Ann Proctor. And Representative, while you're there, after you present this one, we'll go ahead and keep you there, and you can do your next one. So once you're situated, please identify yourself and have your guests identify themselves, please.
Good morning. I'm Mary Ann Proctor. I represent the 60th District in Boone County.
Lewis Kelly, Commonwealth's Attorney for Kentucky's 54th Judicial Circuit, comprised of Boone and Gallatin counties.
Anthony Thigi. I'm a lieutenant with the Boone County Sheriff's Department, currently assigned to the Criminal Investigative Unit.
Philip Ridgel. I'm a major with the Boone County Sheriff's Office. I'm our Public Information Officer.
Thank you. And I notice that we do have a committee sub in the members' packets.
Motion on the sub.
We have a motion on the sub. Do we have a second? We have a motion by Senator Wheeler, second by Senator Reed. All in favor say aye. Any opposed? Ayes have it. The sub is adopted. Please proceed.
Thank you, Mr. Chair and members of the committee. House Bill 4 is a bill that criminalizes the act of grooming. We've got an increasing problem across our Commonwealth of 1 in 10 children are sexually abused, and those are the ones that we know about. Grooming is the intentional, manipulative, and deceptive process where a predator develops a relationship with a child to prepare them for future acts of sexual abuse. What this bill seeks to do is to stop that behavior before it progresses to sexual assault. This came to me from a constituent in my district. Her daughter was subjected to this behavior, and we found out from law enforcement that there was nothing.
Motion on the bill.
We have a motion on the bill. Do we have a second? We have a second by Senator Dean, a motion by Senator Wheeler, that is. And do we have any questions? We have one question by Senator Carroll.
Thank you, Mr. Chairman. And Representative, I sent you some concerns last night on the bill. Help me get comfortable with the aspects of when, let's say, a coach or a teacher, Sunday school teacher, a troubled child, they take their time to work with that child that's having some struggles. Help me get comfortable with the protections that person would have as far as their intent not being misunderstood. And it could be frequent contacts. It could be contacts over text. All those things that you would do to try to help a troubled child that allows you or inspires you to put a significant time into helping that child. Help me understand that that's not going to be misinterpreted.
If I may, Senator Carroll, I think we considered that significantly when drafting this language, and I think you identified the answer to the question through the word intent. This is an intent statute. We have to prove not only that they committed certain objective functions, but they did so with ill intent. It is an incredibly difficult barrier to do as a prosecutor. And looking at this, I think the only way we're going to be able to prosecute people for this is when the intent is so manifest from what they're doing. And if they have a good faith reason, and the bill has been very explicit in creating a lot of exceptions which aren't exclusive, but just examine that it's not designed to punish good faith communications, that I think that intent component, I mean, as a prosecutor, it's the first thing I'm going to look at and go, it's a high bar. It's going to be difficult. But in cases such as the one which involved middle school that my daughter attended, the interactions were so clearly inappropriate that there was no other explanation for it. We could have proved the intent through that. And we think that intent component addresses all of those, along with all of the exceptions that have been specifically enumerated but aren't exhaustive.
Are there any concerns that there will be a chilling effect on adults trying to help troubled kids as a result of this.
I think this bill really is in line with what the General Assembly did at the last session when they passed the bills that govern how people, because this bill is really aimed at people in positions of authority and trust. If you're not in a position of authority and trust, it only counts if we can prove that intent and if the individual is under the age of 14. And so, but as you know, if you have a kid in soccer or involved in any of those things with schools, they have to go through official channels. Most of our youth leagues are going through that. That is just how we're operating now. People know that if you're in a position of authority and trust, there should be designated channels when you're communicating with youth. And so I don't think this will create a chilling effect more so than what our society is generally moving to, which is you're going to be dealing with children. There need to be appropriate means and methods of communication.
Okay, thank you very much. Thank you, Mr. Chairman.
We have a motion. We have a second. Mr. Secretary, please call the roll.
Senator Carroll.
Aye.
Senator Deneen. Senator Neal. Senator Nemus.
Aye.
Senator Reed. Senator Stivers. Senator Thomas. Senator Wheeler. Chair Storm.
Aye. With 8 yes votes, 0 no votes, 0 pass votes, House Bill 4 is amended by the committee. Substitute is passed with reported with favorable expression. Same should pass. It doesn't matter. Okay, well. Okay. Thank you.
Thank you, Mr. Chair.
And if you want to stay seated there. Now we're going to go ahead and proceed to House Bill 264, which is an act relating to theft by deception, sponsored by Representative Marianne Proctor. If you could have your guests identify themselves again for the record, and then you have the floor.
Thank you, Mr. Chair. Marianne Proctor, 60th District, Boone County.
Philip Ridgel, I'm a major with the Boone County Sheriff's Office and the Public Information Officer.
So this was brought to me by our realtors, and again, law enforcement. We are finding there's bad actors out there that take legitimate real estate listings, whether it's your home, a commercial building, or vacant lot. They list it as their own on legitimate sites, although they have no authority or any claims to that property. So what this is seeking to do is put into existing statute the theft by deception to criminalize this behavior to stop these scammers from.
Motion on the bill.
We have a motion by Senator Wheeler. We have a second.
Second.
Second by Senator Reed.
Stivers got a question.
President Stivers, you have a question?
I do. So I want to understand this, Representative Proctor. I am not the owner of a piece of property, be it a raw piece of property or a residential piece of property or a commercial piece of property. And I go tell Senator Wheeler I do own it and have the ability to sell it, even though I don't, and then I do sell it to him.
Yes, sir, that's been happening.
Why is that not theft by deception already under the statute as it currently exists? Because I have created a false impression for which I get his money. And if there's a prosecutor that doesn't prosecute that, I go back to saying they're a lazy lawyer.
I guess so.
And I think it would also be forgery if they've affixed their signature to a document such as a deed that's then filed in the public record.
Yeah. This has some, I'm not denying that what you're saying is a crime, but I think it's already defined as a crime and has multiple criminal acts in it.
Sir, respectfully, what we've encountered is that there hasn't been. So the realtors can speak to how this is going on. Many of them have their own brokers, their own corporations. It's a whole scam that they're doing. And I think our major here can speak to what's been happening in Boone County, where we've seen it, where clearly there wasn't some statute that was prohibiting this.
Yep.
There is a statute that's set theft by deception. It's as if I tell you I own something and I don't. I am deceiving you into a false belief in an effort to get your money. Look, I did this for 6.5 years, and have, as a prosecutor, and a lot longer as a criminal defense attorney. But the statutes already exist to cover exactly what's here. If the county attorney and the Commonwealth attorney aren't prosecuting, then they're failing to do their job.
I think from our perspective, what we've also run into, of course, with any scam that we see nowadays, there's jurisdictional issues. That's not oftentimes the physical selling or, the transfer of. It's by way of post. It's stealing those images off of an MLS website and misrepresenting. Now, to your point, the things that we look at are what is already established. We've run into some problems with certainly jurisdiction and pursuing those offenders. However, the false impression and those residents in Boone County or any one of the respective counties are still out that money, and it's really kind of trying to shore up a loophole, because what we have found is we tell these victims, well, it occurred over there, the property was in another county, and we're trying to find a way to better serve victims who've either had their property stolen, misrepresented, or scammed out of their good hard-earned money.
Representative Nemus. I'm sorry, Senator Nemus. Senator.
Well, first of all, I hope that Senator Stivers, when he said he's been doing this for years, he was doing it as a defense attorney, not actually selling the properties for years like this. But I think that there is a way you would sell this legally is what I hope you're taking care of. I can sell my interest in something, and there's a legal term for that I really have no interest in. So I sold you nothing, but I sold it legally to you. And there's another thing that people are doing is they're not necessarily saying they own it. They're marketing your property without you knowing it. And then if they sell it, they run to you and say, hey, I'll buy your property for this. And then they resell it to them. Is that this bill taking care of that?
Yes, sir, it is.
Thank you.
Senator Wheeler.
I do agree with Senator Stivers on that there is, I think, a statute that would take care of the, I guess, consummation of the transaction. I mean, the way I read the bill, and perhaps I don't do as much criminal law, is that it's just kind of clarifying that theft by deception statute to say if you actually create this listing without proper authority, maybe the transaction itself doesn't have to be completely consummated in order to be guilty. Is that a fair statement, or?
That would be fair.
Okay, thank you.
Seeing no further questions, we have a motion by Senator Wheeler, a second by Senator Reed. Mr. Secretary, please call the roll.
Senator Carroll.
Aye.
Senator Deneen. Senator Neal. Senator Nemus.
Aye.
Senator Reed.
Aye.
Senator Stivers. Senator Thomas.
Let me explain my aye vote.
Yes, please.
President Stivers is right. I mean, the action already involves an intent to deceive through false representations of another for the taking of the personal or real property of another. So it already meets all the elements of theft by deception. But again, specificity is not bad here. I think what you're seeing in specificity, Representative Proctor, and for that reason, I'm an aye vote in this case.
Senator Wheeler.
Aye.
Chair Storm.
Aye. 8 yes votes, 0 no votes, 0 pass votes. House Bill 264 is passed and will be reported with favorable expression.
Motion for consent.
Based upon the conversations, we're not going to put it on consent. Thank you for the motion, however. Thank you, Representative.
Thank you, Mr. Chair and committee.
Go ahead and proceed to House Bill 188. That's next on our agenda, sponsored by Representative Kevin Jackson. Once you're situated, just identify yourself and your guest for the record, and you have the floor.
Thank you, Chairman Storm. That chair looked like it was sitting on the ground, so I thought I wanted to sit a little higher. Kevin Jackson, State Representative, District 20, Bowling Green, and Warren County.
Stephen Harmon, Jailer of Warren County. Do it again. Stephen Harmon, Jailer of Warren County.
Chairman Storm, committee members, I want to thank my friend Jailer Harmon for being here this morning. He brought this bill to me and my attention last summer, so we have been working on it, been vetting it. Basically, it does two things. House Bill 188 does two things to help with the mental and physical safety for those working in our jails and correctional facilities across the Commonwealth. Number one is a peer support counseling program. Right now, the law doesn't protect anyone with peer support programs in place except for police officers. This bill would change that to say peace officer, which would include jail employees as well. Number two, assault in the third degree. Currently, if a nurse or medical staff is attacked in the jail, they can only be charged with a misdemeanor. This bill would expand the scope of assault third degree to include healthcare workers in jails and other correctional facilities. Now that would bring the charge in line with nurses and medical staff in hospitals and doctors' offices. HB 188 is supported by the Kentucky Jailers Association, KCO.
Motion on the bill.
We have a motion on the bill. Do we have a second? Second by Senator Reed. Mr. Secretary, please call the roll.
Senator Carroll.
Aye.
Senator Deneen. Senator Neal. Senator Nemus.
Aye.
Senator Reed. Senator Stivers. Senator Thomas. Senator Wheeler.
Aye.
Chair Storm.
Motion for consent.
8 yes votes, 0 no votes, 0 pass votes. House Bill 188 is passed. We reported favorable expression. Same should pass. We have a motion for consent. We have a second. I'll make a second. We'll put it on consent unless anyone's objectable. It's on consent. Thank you for your testimony.
Chairman Storm, could I brag on our jailer just a second real quick? He drove up here a couple hours this morning, and I just wanted to, Jailer Harmon's in his 9th year as the Warren County Regional Jailer. Our jail houses approximately 700 inmates on a daily basis. He has a staff of 100 people, 30 contracted medical and food services individuals. So just wanted to give a shout out to him and all jailers across the state. They do a job I don't want and most of us wouldn't want, but we sure appreciate what they do.
Thank you. Thank you, Jailer, for your service to the Commonwealth
Thank
and
you,
your
sir.
citizens.
Thank you, Chairman.
Appreciate it.
This time we'll go ahead and move into House Bill 312. It's last on our agenda. An act relating to concealed firearms and deadly weapons, sponsored by Representative Maddox. Please identify yourself for the record and your guests, and then you have the floor.
Good morning. I am Savannah Maddox, and I represent the 61st House District.
Senator Aaron Reed, District 7.
Art Tom, I represent the National Shooting Sports Foundation.
You have the floor. Thank you.
Thank you, Mr. Chairman. First of all, I'd like to thank you for allowing me to present this bill, and committee members for your time in considering it. I will try to be respectful of your time as well. House Bill 312 is a straightforward but important update to Kentucky statutes that will expand the ability of law-abiding citizens to exercise their constitutional rights to keep and bear arms. Right now in Kentucky, citizens who are aged 18, 19, or 20 can legally vote, sign contracts, join the military, serve in combat, start a family, own a business, and possess a firearm. Yet under current law, these adults are prohibited from carrying that same firearm concealed for self-defense. This creates a dangerous inconsistency. We recognize their adulthood and the responsibilities that come with it in virtually every other area.
Motion on the bill.
We have a motion on the bill. Do we have a second? I'll go ahead and make the second. We do have some individuals that are signed up to speak against the bill, so we'll go ahead and take their testimony before we take the vote. Mr. Eddie and Kimberly Burris, perhaps?
Yes.
Thank you.
Chair, Whitaker wanted to sign up as well, but he got here late.
Well, I've only got 2 individuals that have signed up on this list, and this is the official list. So respectfully, you two can come up and speak.
Good morning. My name is Kimberly Burris, and I'm a retired Fayette County Public School social worker with a rank 1 and a specialty certification in school social work. In my tenure in the public schools, I developed a dropout prevention program for our district and then served at Beaumont Middle School as their full-time social worker. There, I was responsible for everything from crisis intervention and threat assessments to program development, small group counseling, and conflict resolution services. Navigating conflict and understanding the dynamics of threats of violence were an everyday reality in my line of work with the schools. Public school educators and support staff are on the front lines of some of our most difficult and complex social and public health dilemmas. The gun violence in our nation should be approached as a public health issue, and in as thoughtful and judicious a manner as possible. Our young people deserve this from us. The Johns Hopkins Center for Gun Violence Solutions in the Bloomberg School of Public Health provides data that firearms in our country are now killing more children and teens than our car crashes and cancer. This disturbing milestone was achieved in 2022. The latest data from the Gun Violence Archives reveals that in 2025, 1,038 teens were killed and 2,749 were injured from gun violence. We now understand that our brains, and notably the parts that govern impulse control, do not reach their full maturity until our mid to late 20s. The part of the brain behind the forehead, the prefrontal cortex, is one of the last parts to mature. This area is responsible for skills like planning, prioritizing, and making good decisions. In my line of work, if a student was on a trajectory of violence, the goal was to intervene and interrupt that path toward a violent resolution to a conflict or an overwhelming emotion. Lowering the age of concealed carry would only make it that much more difficult to interrupt and resolve conflicts that inevitably arise in a school setting, or the painful and difficult problems that are brought into a school because of the larger home or neighborhood issues that are a reality in the lives of our students. Many, if not all, legislators say that they respect the work and service of our public school teachers, our school staff, our police, our firefighters, and public health nurses and doctors. Please, if you are sincere, then you must not make it harder for us to do the work that we do.
Thank you. And Mr. Eddy, if you'd like to go ahead and offer your testimony.
Yes, sir. My name is Chuck Eddy. Thank you for the opportunity to speak with your committee. Please vote no on HB 312. I'm a grandfather and a volunteer for gun violence reduction. I'm here today because I'm concerned about my 14-year-old grandson. He will enter high school next fall, and I'm scared for him if this bill passes. Extending concealed carry to 18 to 20-year-olds opens up danger in our communities. Gun violence has become the #1 killer of kids 18 and under, as Kimberly mentioned. More than cars, more than sickness, guns. I know an argument is that people of that age can serve in the military and handle guns. I have a lot of veterans amongst my family and friends, including Whit Whitaker behind me, who's a veteran. They are carefully trained and don't keep their weapons with them when not going to be in use. I'm concerned that people of this age are not fully mature enough. I worry about concealed carry at the mall, a skate park, at the club, and especially at schools. Now, I know that guns are not currently allowed in schools, colleges, hospitals, airports, but I expect that teenagers getting used to concealed carrying will try to bring them to schools. And metal detectors and security are not perfect. I know from a high school friend of mine that some students are even waved around metal detectors. A student playing the sax gets waved around. He could have a gun in that case. And that's a person I know that's actually having that happen. I ask you to vote no on HB 312 and protect our children, grandchildren, and our community. Thank you.
Thank you, Mr. Eddy. this time, we have a motion and a second. Representative, if you'd like to come back to the table. Oh, we have a question by Senator Carroll.
Thank you, Mr. Chairman. Representative, on the, and I do appreciate the addition of this, the provisional license, I don't see anywhere on here where it requires any training to receive that license.
Yes, for the provisional permit that we have in this bill, all of the same training requirements, a background check, training, and in terms of operating safely, storing, and handling the firearm are required. I would also like to clarify another point. No aspect of this legislation pertains to our schools, neither does it change anything about where it is lawful to possess or carry a firearm. Thank you.
Thank you for your clarification on that. Mr. Secretary, please call the roll.
Senator Carroll,
Explain my no vote, Mr. President.
Yes, please.
Or Mr. Chairman. I keep promoting
please.
you during this session. Mr. Chairman, some things are just best left alone.
Senator Deneen,
Aye.
Senator Neal, Senator Nemus,
Aye.
Senator Reed,
Explain my aye vote, Mr. Chairman.
Yes, please.
I'd like to add that this bill in no way affects the ability to purchase firearms. It does not change the law in which an individual can purchase a firearm in this state. So I vote aye.
Senator Stivers,
Explain my vote.
Yes, please.
You know, most of you all know who are in here that I had a son that was 19 years old, went into the Marines. I think before he was of age 20, he had a TS2, which for people knowing, that's a top security clearance too. He was one of the few people in the world that could be armed in the presence of the president because he was attached to the White House detail, and he was 19 years old. I don't see why he would be disallowed, as the law currently exists, to not do what you're all advocating he should be able to do when he can be standing in the presence of the President of the United States armed at 19 years old.
Senator Thomas,
No.
Senator Wheeler,
Aye.
Chair Storm,
Aye. Six yes votes, 2 no votes, 0 pass votes. House Bill 312 is passed and will be reported with favorable expression. Same should pass. Thank you.
Thank you, sir.
Seeing nothing else on our agenda, this concludes our